Hey everybody. So I just kind of want to give you guys a little bit of game, a little bit of knowledge of pretty much if you guys ever need to sue a corporation for whatever reason, not just a corporation, but anybody in general here in the state of California, there's a few steps that can help you out to make the process a lot smoother than, the way I had to find out was through trial and error. And I brought you this video together today just to kind of give you guys more or less like the outline or the blueprint of the process and how it's supposed to be done. So here we go. In this country, first of all, I want you guys to understand that in this country, you can sue anybody for anything. And that is the very first thing that my business law professor told us when I had his class. Rule number one in business law courses: whether you win is up to a judge. So you can sue anybody for anything here in the state of California, but when you guys make it to the court, it's up to the judge to decide if you have a valid reason, valid claim. A lot of the times, what happens though is when you sue a corporation here in the state of California, usually they do not want to go to court. Why? Because a lot of the times they have to hire a lawyer or some representative that has to either, if it's not local to your area, they have to fly him from usually like from a bigger city, or he has to make the drive all the way to wherever you're at. So a lot of the times, what ends up happening is you'll send a letter of intent to a specific company or corporation, and they can respond, and sometimes they will respond and try to settle with you before it gets to court. But if they don't, then that's actually when you begin the process of taking them to small claims court. Here, I performed a simple Google search of asking, can you sue anyone for anything in the US? And this was my result. Yes, it is true that in the US, anybody can sue anybody for anything. However, it is worth noting that there are also recourses when cases are filed without any merit. For example, a defendant can countersue for frivolous lawsuit or abuse of process if a lawsuit is simply ridiculous or pure harassment. Meaning, you can't turn around and sue Red Bull just because their energy drink did not give you wings. They can actually turn around and countersue you for that. And if the judge sides with them, you're going to end up owing Red Bull some money. So just be mindful of those kinds of scenarios. As long as your complaint meets the criteria and you have sufficient evidence, yes, you can virtually sue for anything. Just because you plan to sue someone, it doesn't mean that you will win your case. This is where you need the help of an experienced attorney who can determine how you should proceed. In my situation, I had just finished taking a business law course, and at the same time, I was dealing with issues with a truck that I purchased brand new from the dealership with like 7 lot miles. And I had spoken to other people that were dealing with the same similar issues as I was. The AC was not working properly. Um, the car was glitching out. I was driving 60 miles an hour, and the entire car would come to like a weird stop. And within a matter of a split second, it would start up again. It was just so weird. It was dangerous. And pretty much ended up happening at the same time. I received a letter from an attorney talking about a limit law, and that there was a lawsuit with vehicles of that year, ranging within that year, and they asked me if I wanted to join in this lemon law lawsuit, and I had decided to just take it upon myself to say, hey, you know what? I'm going to put some of the things I learned in business law to use and take this to small claims and deal with it myself. At this point, I really didn't want a lot of money. I just pretty much wanted the money that I had invested into getting the air conditioner repaired, and it was about $3,000. Some of the defects regarding General Motors did have to do with the compressor and the way it sat, and it was placed in the Chevy Silverado trucks from my specific vehicle was a 2015. Um, the compressor was hanging, and there was tension on this pretty much this pipe that the Freon goes through. And what was happening was the weight of the compressor was causing that pipe to crack and leaking out the Freon. And I mean, nobody knew that. Not even the mechanic shops knew that. So they kept telling me it was the fan. And then they actually were supposed to have replaced the compressor, and because it's not the actual compressor, but it's the valve pretty much connecting to the compressor that was leaking. So like nothing was fixing it, and it's pretty much it all goes back to General Motors. The thing with General Motors, they have these engineers that design these vehicles, and they know that they have issues like this, but they still let them go off of the lot like that, and they let them go off of the line, and they put them out on lots and sell to people knowing that there's defects. I mean, we get them all the time, right? We hear about it all the time about these defects with these vehicles. So this is the situation with General Motors. So I take it upon myself to sue them, right, in small claims. So these are some of the steps that must be taken. First of all, you must notify the defendant with a letter of intent. It's very simple. All you really have to do is get a Word document, right? And be vague as possible. Because the way I see it is if you go into detail about what you're suing them for, they might not, you give them more ammunition, and to spin your words around when you go to court if it does come to something like that. So the less you tell them, the more vague you are, the better, in my opinion. And pretty much what I just did was I got a Word document, I typed up to whom it may concern, General Motors, I'm letting you know right now that I intend to sue you guys in small claims court out of this specific county in California. This is my name. This is my phone number. This is my email. You can contact me there. That's all I did. And I sent it off to their corporate office. So you do have to find their corporate office. It doesn't necessarily have to be their agents, their registered agent registered agent for process service, but you can mail it straight to the corporation itself. So pretty much that's what happened. And the reason why I did not go to the local dealership is because I looked at some of the laws, and some of the laws says that you can sue General Motors themselves because they are the manufacturer. You might want to look a little bit more into that just to validate what I'm saying. But I found it myself. If the defendant doesn't, if the defendant responded, you must try to reach an agreement with them. So if they respond, you might, say, hey, I want so much $3,000. In my situation, it was 3K, for all the expenses that I paid, but they never responded. So if the defendant does not respond, make sure to go to the proper venue that has jurisdiction. This can mean several different courthouses that you can use. The one that I did was the one in my county because I think with a vehicle you can choose either the within the county that dealership is in where you purchased the vehicle, or you could use the county where you live. And for me, coincidentally, it was the same county that I purchased the vehicle in is the same county that I live in. And this is just an extra page right here from this specific website right here at the bottom on the right hand side. And if you'd like to, I will put this in the description. That way you can check it out. But it pretty much kind of solidifies what I was saying as far as have you asked for the money yet or the property? Pretty much kind of what I said about sending them a letter of intent. It's the same thing. In legal terms, you must make a demand. It says right here in that first paragraph on the other person, if possible. Your request may be made orally or in writing. I'd like to do writing just because you want to keep documentation of all that stuff, but it's a good idea to do it both ways. Okay, so and then it also says always keep copies of any letters and other written communications. Okay, so how much money does your dispute involve? In my situation, it was only $3,000 that I was asking for. There's some information right here. Small claims have in that specific middle paragraph. It says small claims have an upper limit in the amount of money that a party can claim. You can sue for up to $10,000 if you are an individual or a sole proprietor. Corporations and other entities are limited to $5,000. In addition, a party, individuals, or corporations can file no more than two claims exceeding $2,500 in any court throughout the state of California during a calendar year. So, pretty much what I'm getting from this is that you can sue up to, I think, so many times, charging $2,500, and then you're only allowed, I think, 10,000 twice a year if you needed to sue somebody else. If you do exceed the two cases over 2,500 per calendar, the court may award you only a maximum of 2,500 in each subsequent case, even if your proven damages exceed 2,500. Um, so this is in case it goes to court, but like in my situation, and I'll get into this a little bit into detail a little bit further, but we ended up settling with a mediator before we even walked into the courtroom. So this is only in case if in the situation that you actually have to go before the judge. And man, it was just crazy how it seems like corporations and their attorneys do not want to go into a courtroom. It seems like it's just easier for them to settle outside of court for whatever reason. Maybe it requires them coming back multiple times. So in my situation, we settled right outside of the courtroom. Here's some more information pulled out of the same website, and pretty much it's stating how quickly must you file your case. As a general rule, you have 1 year from the date of the violation, the breach of contract, or from when the discovery was made of the breach of the contract. Typically, we have 1 year, but some other rules apply. It varies. For personal injury, you have 2 years from the date of injury or when it was discovered, 2 years from when the oral contract was broken, 4 years from when the written contract was broken. And you guys can look at all the details if you'd like. You can pause the video, look at some of the details as far as what's specific to your case. Before you begin filling out the SC100 forms and actually doing the filing, you want to first find out who the agent authorized for service is. And if you're suing a sole proprietor or a small business that isn't incorporated, usually you can get away with just mailing the forms directly to them or having somebody serve them. Um, but in my situation, it's a corporation, and with every corporation, they have to have a agent authorized for service. It's usually not them, and they are really, really good about hiding their agent authorized for service. They use somebody else. There's businesses that actually start up, and the main idea behind this business is to take in all the letters for a corporation that's being sued, um, and forward that information to the corporation that's being sued. They pretty much get their mail and they read it for them, and if it's like a lawsuit, then they forward it to them. But it's really, really hard, and you cannot start a small claims process without having that specific agent authorized for service, and it's very, very tricky. Trust me, it can become a headache. It can be easy for people to give up at this point, but that's why I'm here to give you guys some gold and give you guys some knowledge on a way to figure it out a lot easier. Because typically you have to go to the Secretary of State's website, and like in my situation, I went to the Secretary of State's website and I tried typing in General Motors, and I got like 2, 3 pages of different General Motors corporations, and I had no idea which one to get a hold of. Eventually, I was able to find the right one, but here's another little trick that you can do. You can call the city where that business operates and find their DBA name, which is doing business as name, and you call like the city and you ask to speak to their business and licensing department, and then once you get on the line with those people, then that's when you kind of ask them, hey, I'd like to request what this specific business is doing business as name, because then you'll have that specific information that you can then plug those numbers in, or those letters in, whatever their name is. You can plug it into the Secretary of State's website. Here in California, it's the sos.gov website. You can plug that in, and it'll give you exactly that specific business. For my situation, it would be General Motors. It was a specific General Motors LLC company, and once you find it on the Secretary of State's website, you click on a little link on that specific name, and then it'll pop up another page that will tell you the agent authorized for service. If you guys have any questions, go ahead. Feel free to put them down in the comment. I will try to respond to them as soon as possible because I know at this point it gets a little bit tricky. I'm going to backtrack a little bit because this is the next page in my slide, and pretty much touches on the topic of where can you file your claim. This is a little bit trickier, so it kind of varies as far as where you can file your claim, just depending on what type of contract or what you were financing. The right location may be any of these, right? One, where the defendant lives or where the business involved is located. Two, where the damage or accident happened, right? So, I mean, if I would have gone into a car accident and another county, then I guess you can usually file a claim. Like say you get in a car accident and it's you live in Tulare County, but the car accident happened in Kern County. You would probably have to file up in Kern County just because they have jurisdiction. Where the contract was signed or carried out, just depending on what kind of contract. If the defendant is a corporation where the contract was broken, or for a retail installment account or sales contract or a motor vehicle finance sale. So for me, this is particular right here for me because the reason why I sued General Motors was over the purchase of a vehicle where I financed the vehicle. And this pertained to me where the buyer lives, which is A, or B, where the buyer lived when the contract was entered into, where the buyer signed the contract, or where the goods or vehicles are permanently kept. So that right there can vary because you can buy a vehicle in one county and then you live in another county, and then what if you have your car or your vehicle or your good or your vehicle permanently kept somewhere else, so like a storage unit or some sort in a different county. So that varies. But you always want to try your luck just following whatever county you feel comfortable in, you think is right, and they'll tell you eventually if you're in the right county or not. And it's called venue. The rule is called venue. This topic here is key. So the fee waiver packet will come with two forms, F001 and F003. It's very key because I use this when I filed my small claims due to the fact that I am on Medi-Cal with right here within the state of California. I am on Medi-Cal, which is kind of like a government health insurance, and pretty much it allows me to fill out a fee waiver and have these court documents the fees waived. This is straight out of the SC 100 form, or actually, this is out of the SC 100 form, and then this is actually the little bottom little image here is from that same website that I clicked in the link. You can scroll down to fee waivers, and there's a section called there's a little tab called fee waiver button. And it says here, fee waiver of fees. The court charges fees for some of its procedures. Fees are also charged for serving the defendant with a claim. The court may excuse you from paying these fees if you cannot afford them. Ask the clerk for the information sheet on waiver of superior court fees and costs. Form F001 info to find out if you meet the requirements so that you do not have to pay the fees. And if you're in a situation like I am, and hopefully I'm not like that forever, but if you're in a situation that I am in, where you either have Medi-Cal, here in California, we have this like an EBT called SNAP. If you're on SNAP, if you're on Medicaid, which is for seniors, or you're on some kind of government assistance, you automatically qualify for this F001 fee waiver. And the good thing about it is that, so it's like two different sets of forms you have to fill out. F001 has, I think, 2 pages, and F003 is only 1 page. But if you get any government assistance, like it automatically waives the fee and you do not have to fill out the entire forms. There's like a section at the very top where it just says, hey, I qualify because I get, Medi-Cal or I get SNAP, which is EBT, and you don't have to fill out the rest of the form. You just sign it. Here is some additional information out of the F001 info form, and pretty much it explains and gives you a little breakdown of what will qualify you for the fee waiver. The full names of these programs can be found in Government Code Section 68632A, and are also listed here. So these are in order to get your your court fees waived, which is like I said, if you have Medi-Cal, if you get food stamps, California Food Assistance Program, CalFresh program, or SNAP, SSP, State Supplement Payment, Supplemental Section Inc., Supplemental Security Income, not Social Security, County Relief, General Assistance, IHSS. So if you are in any of these programs, this automatically qualifies you for the fee waiver and will waive the court fees that you might usually have to pay otherwise if you didn't have these or if you weren't in these programs. So good information to know. Really, really good because this will save you a few $100. And in order to get the small claims packet downloaded onto your computer, you can download it onto your computer. And if you have Adobe Acrobat, I think it's Reader, you should be able to fill out most of the form on your computer. Just type in the answers because it allows you to kind of add text into the packet. But pretty much on that website that's in the description here in this on this video, there's a section as well that says small claims. You have to just scroll down to it. You'll see a small claims packet. You're gonna click on that link, and pretty much it's gonna open up that packet for you. And this is what the SC100 packet will look like. This is the first page. You should see plaintiff claim in order to go to small claims court. You fill this out to the best of your ability. If you screw something up, don't worry. Once you go to the courthouse, they'll kind of redirect you if you do anything wrong. It's usually very easy. You could do it right there on the spot and just get it resubmitted. But right here in the little bit lower section of this form is where you will have to put the agent registered for process service. So there's a little bit more information regarding the SC100 form. Right here, this is the SC100A. So if there's other people involved that you are suing, or other plaintiffs or defendants, which is, say it's you and another individual that are suing a defendant, like a corporation or vice versa, just you suing more than one defendant. And this can fall under various different scenarios, but you add this to your copy. This comes, I want to say, yeah, it does come with the SC100 form at the end, but if you don't need it, you can just discard it. What you want to do is make copies of all the pages of this form and any attachments. So once you're done filling out these forms, you want to make 3 copies, one for you, one for the party that's going to get served, and one for the courthouse. And then when you take it to like a sheriff's office to serve your paperwork, they're probably going to ask you to make some additional copies as well for their records and some for the other party's records because remember, you do have to serve the registered agent for process. So, yeah, and every county works differently. They all serve differently. They all request different paperwork. So, yeah, just keep that in mind. This is attached to the SC100 form. And it's pretty much if you have other defendants or if there's other plaintiffs in your case, like it's you and like maybe mom suing a corporation for whatever reason, or if there's more than one defendant, like you're suing more than one person, you want to attach this form, fill it out, and it's kind of self-explanatory. If there are more than 2 plaintiffs, person, business, or entity suing this, or if there are more than one defendant, person, business, or entity being sued. If not, you can just discard this. You don't have to attach it. Um, you look up right here at the top, the little paragraph, it does say make copies of all the pages of this form and any attachments. A minimum of 3. When you go to the courthouse to file the paperwork, you want a minimum of 3 copies, one for yourself, one for the court, and one for the defendant. And then when you have somebody serve the registered agent for process, then the sheriff's office, usually if that's what you go with to serve your paperwork, they're probably going to ask for some additional copies, some for their records, some for that registered agent for the process server. So yeah, there's like just be ready to make at least 5 to 6 copies your original forms as well as the F001 form. This page right here is the SC104 form. It's for proof of service, and you're pretty much gonna mail this to the serving party, which is, for in my case, it was the sheriff's office. But whoever you have as the process agent or the process server, they're gonna send this over to the registered agent for process. And this page here just kind of buttons up everything that we kind of went over. You must then go to your county courthouse and file the paperwork and receive a court date. That's after you have filled out all the forms and taken 3 copies. You go to the courthouse. You get a court date. Then you will need to have a process server serve the defendant's registered agent for process. After you're done with that, a sheriff will serve your paperwork and honor it with fee waiver if you're eligible for that fee waiver. Once again, and I already kind of described what will qualify you for that. That this page right here is just a little bit more additional information. It's called the SC104C form, and it pretty much says how to serve a business or a public entity. And you can go ahead and just kind of look through this and get a little bit more insight on exactly how the process is done.
Going back to my case against General Motors, um, we walked inside of the courtroom and they did roll call. Then we had a short recess, and while I was waiting outside in the hallway, and so was the representative for General Motors, a mediator came up to both of us and asked if he could speak to us. Stated what his job was to mediate, between both of us and see if we could come to some agreement before we go back into the courtroom. Um, we had a conversation, went back and forth a little bit. He offered me $1,000. At this point, I was kind of over it. I'd already sold the vehicle for one. I was missing a lot of information, and I could have done some digging to get the information as far as like the mileage on the vehicle of what the mileage was when I sold it. I was just really over it. I had a lot going on. A college student, have kids, didn't have time to really do all that digging into it. So I ended up taking $1,000, and we settled outside of court. I'm pretty sure that might work. It might work that way in a lot of other counties. Just I can't say for sure, but that's how it works in Tulare County, where our case was being heard. So yeah, the mediator had this contract. He kind of like just filled it out, and then he had another page to that contract where it kind of gives a description of our agreement, and we agreed to $1,000. I got the paycheck within like 2 weeks, and then we had another court date on the 18th of August just to make sure that they paid me the money. I didn't even have to show up. If I didn't show up, the judge would have assumed that I got paid, which I did. I got paid within like 2 weeks or a week and a half. So I never showed up, and the case got dismissed. General Motors did reach out to me via email, and they just wanted me like to write up a contract, kind of reiterating what happened in court. That once I got payment, the case would be closed, and that I would no longer pursue, compensation from General Motors, and which I did. I typed up an email real quick and sent it back to them, and yeah, the case got closed, and I got $1,000 out of it. It wasn't the 3,000, but hey, something's better than nothing. If I had more time and more resources, I probably would have fought it out a little bit harder. But at this point, because I had already sold the vehicle, I just took $1,000 as a hey, you know what? I learned something, and I got compensated for my time, and having to file this paperwork and for some of the repairs in on my vehicle as well. So yeah, I took the $1,000, and yeah, I ain't complaining. This is just my bank account. When I got the money deposited into my bank account. So yeah, it was pretty fast after the court hearing. So yeah, if you have any additional questions, feel free to leave them in the comment section, and I'll do my best to try to get back to them because there's a little bit more detail to the my case, but just for simplicity's sake, I'm just gonna leave it at that. So